We got our circuit court people from Hampton. Girl, you know Newport News called and threatened me for having y'all over here. They ain't saying like mean or nothing, but they did say why I called y'all. And not them. But the thing was, they helped me work out a situation that I was dealing with. I was helping one of my clients who we'll be presenting together today to help them deal with a probate situation that they were dealing with one of their clients in Hampton. They came through. You hear me? They came through, man. So what a microphone. Somebody got a microphone in their pocket. Turn it off.
Sorry, that's us.
Who?
Sorry.
It's all good. Oh, that's y'all. Never mind, y'all about to come now. Y'all keep y'all's on. Come on up here. 'Cause I'm talking too long. She's like. Anyway, we got Miss Carlisa Deloach is coming, Miss Melissa Gary, and Attorney Veronica Williams. They are going to be up here to present to you all. Clap for them and make them feel good. My goodness. Now, remember when I told y'all Uncle Sam was coming to teach y'all something? This Uncle Sam right here. Aunt Sam. No, seriously though, they work for Hampton Circuit Court, and they help other people get through the system that's there. Anyway, for probate. But I love them so much because even though they don't have to do a lot of stuff they do walk people through it, but they go beyond the call of duty. And thank y'all so much for helping my client out of that situation. All right, I'm gonna leave you alone because she keep messing with her microphone and tell me to go out the way. All right, see y'all.
Good afternoon. My name is Veronica Williams. I am an attorney here in Newport News and been practicing for more than 25 years in the area of elder law, estate planning, and estate administration. And I'm not technically a part of the circuit court team. I'm here to support the circuit court team. These ladies work for the clerk of courts in the city of Hampton. They are your probate clerks. So anyone who goes through probate administration in the city of Hampton, you're going to be served by one of these ladies. And I can tell you that I've been working with one member of the circuit court team for over 20 years. So you're about to hear today from, if not the most experienced probate clerk in the Commonwealth of Virginia, one of the most experienced. So our presentation is going to be a little bit different. Everybody else had the PowerPoints. I'm accustomed to dealing with seniors, so I have paper in hand. So everyone should have a one-page sheet of questions. Raise your hand if you don't have a one-page sheet of questions. Wonderful. So what we're going to do today, and I've found over the years in serving as a presenter that I really want people to walk away with an understanding of the subject matter. We've been asked to teach about probate today, so we're going to walk down this list of questions. And we're going to ask the question. We're going to pause for a moment just to give you an opportunity to ponder what the answer might be, and then we're going to answer the question for you. This is the stress-free zone. And the subject matter is far too in-depth for us to ask you to hold your questions until the end. So we're going to invite you to ask us questions as we go along, okay? I want to manage your expectations and let you know that we may not get through all of the questions. And if there's a question further down the list and you see that we're running out of time, just let us know that you want us to deviate from the order so that we can address that question before our time expires. The other thing I'll share with you is that the probate team, the circuit court team, they are here representing the clerk of courts. And I'm talking the constitutional officer, the elected official who runs the clerk's office of the circuit court, and they are not permitted to give legal advice. So if you ask a question and they feel like it would make them run afoul of the law, they're going to punt to me. So I'm really here to support them. Okay? Wonderful. So let's get started. Question number 1, true or false? There are 3 types of probate. True, the answer is true. And those 3 types of probate, the first type of probate would be a death probate. When someone passes, if the manner in which the estate is structured requires probate to access the resources, they're going to go through probate. The second type would be a living probate. This is when an adult has an accident, an injury, or an incapacity, and they need a guardian. So someone has to petition the court for the appointment of a guardian and a conservator. And that person then is going to lose their civil rights, and they're going to essentially be reduced to the status of a minor. But every penny that conservator spends, if a conservator is required, because sometimes only a guardian is required, but if a conservator is required, every penny that's spent has to be accounted for and filed in the public records. So that's a living probate. We talked about a death probate number 1, living probate number 2. The third type is when a child encounters resources. It may be that someone named a child as the beneficiary of a life insurance policy. Well, because children do not have the legal capacity to own property, they're not going to be able to file and sign that claim. So someone's going to have to be appointed by the court to serve as the child's guardian and the guardian of the estate, and that's another probate. And every penny's going to have to be accounted for. There's going to have to be a corporate surety bond, et cetera. Part 2 of that question, true or false? I can avoid probate. True or false? True, you can avoid probate. Any discussion of probate would be incomplete if we did not discuss ways to avoid probate. And it can be as simple as using your contracts, using on your bank accounts, brokerage accounts, credit union accounts. You can use your signature cards, your brokerage agreements, your membership agreements. You can name payable on death beneficiaries if your distribution scheme is pretty straightforward. Okay? Yes, ma'am.
So all that you said, it's like probate is bad. So probate is having the law involved. Like I'm trying to make sure that I understand and all the.
Somebody needs to take her a mic because I want to make sure I can hear you and that I can understand. I feel like I need to run down and give you the mic.
So I just want to, for clarity, make sure I'm understanding probate. All of it sounds not good. I want to avoid it. But does that mean that that's when the law gets involved in whatever decision making? Like if I'm trying to define it, make sure I understand what probate itself is.
And I see the ladies. Y'all want to address it or y'all want me to take it? Okay. Probate is that process whenever, if it's a death probate context, if you pass away and there is no mechanism to access your resources, you're going to have to seek the court's assistance to access the resources. If you encounter an incapacity and your loved ones cannot access your resources, and there's no one who has the authority to make medical care and treatment decisions, we're going to need to seek that authority from the court. So probate is a process where we haven't put something in place. The law will always allow you to contract with respect to your person and your property. But when we haven't done that, the law says that we've been silent. So there are state statutes to step up. And some of those circumstances are going to require a court order or court intervention. And I mentioned that the clerk of courts is a constitutional officer. You know that senators and congressmen in the state have those numbered license plates. The more senior they are, the lower the number is. Well, the clerk of courts is an elected official with one of those numbers. So the clerk of courts can grant access in some cases. And when the clerk of courts doesn't feel comfortable or doesn't have the authority, we're going to need a court order. Does that make sense? Did I answer your question? Yes, ma'am. I see another one. Lights are bright. I need some sunshade.
So just for clarity, what I'm hearing is something like a will, a living will, at your employment, human resource office when you sign off who's going to be beneficiary. Those are some of the instruments that will help not need probate.
Yes, sir. I personally don't favor living wills. That's an advanced medical directive. That's another session. But you're correct in terms of the financial power of attorney, the medical power of attorney. That's a great way to avoid the adult incapacitated guardianship. No judge is going to appoint a guardian by court order if there's a power of attorney in place, if there's an agent who can serve, absent there being a showing that the agent has abused their authority and engaged in neglect or exploitation. Okay, great question, sir. That's a way to avoid probate. Excellent. Excellent. Another way, if your distribution scheme is not straightforward, if you have someone that you need to protect in some way that's an heir, you can use a sophisticated instrument like a trust. If your desired fiduciary is out of state, you're not going to be able to waive corporate surety, so you might want to use a probate avoidance mechanism, but it doesn't have to be a trust. It's very fact specific, but you can avoid probate. The ladies will talk about, well, I'm not going to give it away. I'm not going to give it away. We're going to get down this sheet. And at this point, I think we're ready to go to question 2. Which one of you ladies will?
That's Carly.
I'll answer.
All right.
Are you going to read the question or?
You read it.
I'll read it.
Okay.
Question, I want to serve these ladies. This is your circuit court team.
Love it.
Question number 2, true or false? When a loved one passes, any court can probate the will, true or false?
That's correct. Hello, everyone. My name is Carlise Deloge. So when someone passes away, whatever resident address is on their death certificate, that city and state, that's where you would go to probate. Even though you may say, well, they just came with me to while they were sick, or they wasn't here long, but whatever's on that death certificate is the city that you would go to. So be mindful if your loved one passes away and you know that they wasn't a resident of your address, make sure you put their resident address there. And I just want to touch back up on when some citizens come into the office without a will, and they say, well, power of attorney. Just know when it comes to power of attorney of a person, that ends at death. So that document is void once that person passes away, and we see a lot of that happening.
Another thing as far as the where you can probate the will, a lot of times the nursing home address is on the death certificate. That is not considered a legal residence. So if the person passed away or at a nursing home, or if the nursing home is listed on the death certificate, we go to the address prior to entering the nursing home as to where you need to take the will. Because, you know, for a lot of elderly people, that they pass away in the nursing home. And it could be in a whole different city than their home was. So that is also something that needs to be considered as far as where you would take the will to be probated. We get a lot of people that bring the death certificate or come into probate in Hampton because they live in Hampton. And we have to send them away and say, look, no, this person was a Newport News resident. We can't do it. And reason being is when a creditor is looking for someone to pay the debts or claims, they're going to go to the court where the decedent was a resident at the time of death. So that's why we can't use nursing home, and that's why we try to be so careful about where the will is probated or about where we appoint a personal representative. And I'm sorry, my name is Melissa Gary. I'm going to say that.
All right. Wonderful. Let's proceed to question number 3. True or false? You can protect widows and children against creditors when someone passes, and we're talking about the creditors of the decedent, with respect to the inheritance that would go to the widows and the children. Only if you act within 1 year of the decedent's death. True or false? That's true. This is a teachable moment. Listen to me very carefully. There's a statute of limitations in the Commonwealth of Virginia. And if someone passes away, the law has a mechanism to protect spouses that were dependent upon the decedent and minor children. but you have to file the proper statutory claims within 1 year, and if you miss that date, there's no recovery. And I'll give you an example that I had years and years ago. Had a family where dad passed away, single parent. He had 3 children. 2 of them were adults, young adults, like 19, 20. But one of them was 17 years old when he passed away, a month away from turning 18. And unfortunately, they lived in a house that was owned by a slum landlord. And the reason I say that is because the minute that dad passed away, the landlord sent to the commissioner of accounts a claim, a creditor's claim saying that the decedent was in arrears in his rent to the tune of $29,000. And the only thing they had was a life insurance policy. And it was, I don't know, 35 or so, right? But if that spousal claim was allowed to stand, it was going to eat up what dad was trying to leave his kids. And I mean, wonderful father, okay? And, naturally the kids were concerned. They're experiencing a loss and trying to sort through everything. But this statute that's on the books could not use it with respect to the 2 children. There was no spouse. But that young child who was 17 years old at the time of death, now by the time we filed the claims, he was 18. But I'm looking at the date of death. He was a minor. And I filed $64,000 worth of claims, worth of statutory protection for him. There are 3 different claims that can be filed: $24,000, $20,000, and $20,000. Family allowance, exempt property allowance, homestead allowance. Just filed them in the clerk's office of the circuit court. And the commissioner called me. And I hadn't even had a chance to communicate with the commissioner. Commissioner called me and said, Veronica, what do you think about the creditor's claim from the landlord? I said, sir, we don't even have to consider it. I just filed statutory claims, $64,000. He was like, oh, okay, would you mind sending me those? Not a problem, sir, they're on the way. Okay, so they took those statutory claims, took priority over taxes. So even if there was some tax lien, they took priority. So I want you to be aware of those protections. When somebody passes away, I get that we've experienced a loss and that we need to grieve. But I need for you to understand that there's business that needs to be taken care of in a timely manner. Okay? Great. Question number 4, our circuit court team is going to address this. True or false? Dying testate means dying with a will, and dying intestate means dying without a will. True or false?
That is true. For those who don't have wills, I just want you to make sure that, like, your bank accounts or life insurance have beneficiaries on it, because it's difficult for your loved ones when they can't access your finances. So make sure that you have your designated beneficiaries. You can use more than one. We've had examples where I had three children came in, 2 adults, one was a minor, 17, and the mother left life insurance. But at the time, the youngest child was young, so the older 2 sisters were the beneficiaries. Well, the mother wishes were for them to split the life insurance by 3. Well, one of the sisters said, no, this is my money. It's in my name. You split yours. So just know, even though you may know, well, my children's not going to do that, or this one is more responsible, whatever your wishes are, if you want to leave everything to all of them or just want to one, make sure you have their names on your bank accounts as paid upon death, beneficiary, or in your wills if you do have a will. Did you want to add to that?
This was a great workshop. We learned how to get a better credit score, how to borrow money, how to increase our wealth. But what do you do when you die with all of that? Where does it go? Who are you leaving it to? A lot of people don't like to discuss death. They think of it as being morbid. Oh, I'll do it later. But we, as probate clerks, have seen some really bad situations. Blended families, excuse me for not standing, blended families. We had an instance, Carlise remembers, a husband passed away. He was married, but separated, hadn't been with his wife for years, and had started dating someone else, and they'd been together for years. His house was, it was in his name. Of course, he didn't do a will, and he didn't do a deed, and he did not marry, did not divorce, for one thing, and didn't marry his girlfriend. You know, just, I had someone in my family did the same thing, just, oh, I'm not going to divorce her, just, she's gone, whatever. Well, he had children to his wife, so when he passed away, that property was, the lady, his girlfriend, had you know, and to be spiteful, of course, because probably cheated on me with her, you get out of that house now. So, you know, it's important to take care of things. We see this, and, you know, this was an older person. You know, where is she going? Also, even if they were married and he didn't do a will, and there were children to a prior marriage, the wife is entitled to 2/3, and she has to give, or 1/3, and the children are entitled to 2/3, unless you do a will or a deed stating otherwise. So we see that happen a lot. People don't like to talk about death or do anything about, you know, their things, but it could play a very important part to, you know, you may not want to leave your things to a son that was just horrible. He doesn't deserve anything. He's on drugs or whatever. Well, if you don't do anything, he's going to inherit part of your estate unless you act. And you can avoid probate. Put POD on your checking and savings accounts, payable upon death, transferable upon death. That way, when something happens to you, you merely take the death certificate to the bank because you're on there as for it to be paid upon death. They even have now, which hasn't been in existence that long, the payable upon death real estate. You can actually do a deed that will transfer your real estate to whomever you want so that you can avoid probate as far as your property is concerned as well.
All right. Thank
Excuse
you.
me, just one quick question. With regards to, say, checking or banking accounts and that sort of thing, if you are joint on that account, you don't have to do that, right?
That is correct.
Just clarity. All right,
That's a good question.
It goes to the
sir.
survivor.
But let me address that for one moment. You go ahead.
No, I just was going to say that we've had problems with that as well. Some banks, even though you are joint, they have, I know Langley has on their form right to survivorship. Mm-hmm. And if that box isn't checked, and even though you are joint, that the other person will not be able to access because you all didn't check right to survivorship. So just make sure you go through your forms, answer each one, and let the bank officer know, no, this is joint, right to survivorship. If anything happens, I want this person is ownership to this bank account.
Thank you.
Mm-hmm.
That's good. Sir, I want to address your question as well. Not only is there this issue of being with survivorship, joint with the right of survivorship, and joint without a right of survivorship, which makes a huge difference in terms of whether it's a probate asset or not, whether it has to go through probate for access. But there's also this issue of whether or not creditors. If you place someone on a joint account for convenience purposes, say that you're serving as caregiver for an aging parent, and they put your name on the account so that you can assist them. That's for convenience. But you have a creditor. That creditor can come and attach mom or dad's account. And if it's a Social Security account, it's against the law for them to do that. But how much time and money does it take you to clarify that? How long is the money tied up? So it's very fact specific. So that's why I think we're talking about payable on death, because creditors can't deal with the payable on death because you don't have access to it until after that. And that's where the powers of attorney come in. If you're assisting someone, right, who's starting to experience the need for assistance, then that power of attorney is going to be helpful. The payable on death thing, this is very fact specific, and I don't want to get too far off, but we mentioned having children who might be struggling with substance abuse issues. I mean, I've seen people who the Lord has gloriously delivered. Okay, I mean, their loved ones live to see them overcome and walk in tremendous victory. But if you're going to do an estate plan for them, you know, while they're still in the process of walking through that, a POD designation may not be appropriate. You may need something a little more sophisticated where you can control the access.
Okay, so just so I understand what you just said, if me and my wife are in a joint account, but we don't have a payable on death, and then I have a tax lien that they try to attack my account, they can attack the joint account. However, if we have the payable on death, they can't touch that. They got to find another way to get to it, even though, is that fair to say?
So let me say this. Husbands and wives have a special protection in the Commonwealth of Virginia. You can own property tenants by the entirety, whether it's real estate or whether, and by statute, you can do that with cash accounts. If it's your creditor only, they can't touch the joint account with your wife, but it has to be your wife. Right. I'm talking to the saints, right?
Right. That's right. That's right.
So we want to live holy before the Lord, because a lot of these protections that I'm talking about, they apply to spouses. God's smarter than we are. Okay, I see Carlise. That's nonverbal communication for I might have a comment.
No, you're fine.
We're good?
Since you're on that, you can elaborate about, and this may be outside of assets, but we've seen cases where an individual, as I was saying before, they were married but separated. His girlfriend goes to make funeral arrangements.
Yeah.
And the death certificate says married. You know, by law, I don't think the funeral director will touch it. You know, so that's just another instance in planning for your demise.
Make them put a ring on it.
Yeah.
Right? Just live holy before the Lord. And make sure he's saved. Don't be unequally yoked. All right. Question number 5. If I die without a will, the state has a will for me. True or false? That's true. Remember, I shared with you that the law will always allow us to contract with regard to our person and our property. And if we choose not to do that, the law says that we've been silent and a state statute steps up. If we don't have a will, we are going to pass intestate. Unless we have used our contracts, then we don't have a way to access that resource unless we have some POD designation, some joint with the right of survivorship. Then we're going to have to go to the probate clerks, be appointed as administrators, and enter probate. And the statute will then determine who our heirs are. And this is once again why you want to make sure you're living holy before the Lord. If you're living with somebody, we do not have common law marriage in Virginia. And even if we did, if you have a pastor, right? So that's a problem if someone passes, because you have no rights. You have no rights to Social Security. You have no rights to property. I can't file spousal claims to protect the inheritance from creditors. Yeah, and we only have 1 minute and 46 seconds, so we're going to have to conclude, but Ladies, do you have anything that you want to say in closing? Because we want to honor the time so that you can stay on schedule.
I just want to say for those who don't have a will and say that you own property and your loved one passes away owning property, your mother passed, no will, then you can come into the office and do what is called a real estate affidavit. That's where the property transfers into that heir. So if she had children, it would transfer into her children's name. If there's a deceased child, that deceased child heirs will get their share. Did you want to
But with that real estate affidavit, all of the people would have to be in agreement to sell it. One person cannot sell that property if it's a real estate affidavit versus if there is a will that names an executor. The executor could have the authority. Usually there's a code section in the will where it gives the executor the authority to sell the real estate without someone else's, without any of the other beneficiaries having to stop them or say anything. So with a real estate affidavit, all of you have to be in agreement.
if they're selling?
Yes.
Okay. Someone has a question? Oh,
We could do it quickly.
okay. Question number
We're on 6.
6.
What's that?
Okay, the appointment of an executor or administrator and formal administration of an estate is always required. The answer is no. You can do it simple. Now, formal qualification means it's based on the threshold, depending how much you have in your estate. If the personal estate exceeds $25,000 and you've got real estate that's a certain amount, you may have to file an inventory and an accounting and open an estate account. The estate account could remain open for 16 months. So the formal administration is a little lengthy. If you just have real estate, you can go to the courthouse, put the will to record just to pass the real estate from the decedent's name to the heirs. No inventory, no accountings, no estate accounts. If the personal estate, checking, savings accounts, cars, fall under $25,000, you can do it with a small estate affidavit, transfer the assets. So that's the difference in the non-formal and the formal. So you don't always have to do a formal probate administration.
We're past time. We're gonna
Okay.
we're gonna send the true false answers to Ashley, and there's also a probate handbook that addresses the probate
That we
part.
have out front.
Anything in bold is legal, but we'll make sure that you get the answers. Okay. Thank you for your time and attention. We want to
Thank you
honor
so
the time
much.
limit
Thank you all.
that Pastor Maxwell has set up for us.
Hey everybody, this is awesome, man. Our Overflow Investors workshop is going great. We've learned how to become bankable. We've learned how to do tax annuities. We learned how to hide our money and tax shelter it. Our goal here is to make sure that we teach people how to make money through investing in real estate. Investing in real estate to me is the easiest way in order for you to learn and to curate wealth. So I'm so happy. We had a good turnout. We had probably about 200 people here today, and it's been awesome. We want to make sure that you're able to not only take care of yourself, but to curate wealth for your children and your children's children and your children's children's children. We want to make sure that you leave a legacy of wealth to take care of your family. And that's what we're going to teach you here in our Overflow.
Hi, I'm Sarita Powers. I came all the way from Virginia Beach to hear Dr. Maxwell. Love it. Love it, love it, love it, love it, love it. Can't wait for the next one. I'm going to definitely buy my first property one day soon.
You can also buy into this program. This is a free workshop, but we have it every month. We're going to have paid for classes, and we're going to give it at a very, very discount rate. Just look at the bottom of your screen, and you'll be able to see exactly what it is that you need to invest in yourself in order to make sure that you not only become bankable, but become wealthy so you can take care of your family.